Okay. Okay, good day to you all, and welcome to this session of Friends of Multilateralism Group, FMG in Geneva. My name is Lu, I'm the CEO of the group, and this is a heavy subject, as we just discussed. And we, FMG, have been doing already a few sessions on this subject in the past, but with some recent proposals, which our moderator Victor is going to share with you, and also you have seen them in the invitation. We think it will be important to build upon that discussion and taking the best use of the proposals by members. Some of them are on the panel today, and we think it will be great to engage all the stakeholders on this subject. So I won't take too much time, and I'll give all the time to the panel. And to you, Victor, thank you very much. Go ahead, please.
Thank you very much, Lou. Hello, everyone. I'm very pleased to moderate today's discussion. As you have seen in the program that was sent out by Natalie, we have a very impressive lineup of speakers today. Ambassador Jean-Pierre Baptiste of Chad, Ambassador Erwin Bollinger of Switzerland, Ambassador Senthiu Pandian of India, Ms. Li Yihong of China, my friend and fellow member of the FMG, Hamid Mamdou, who will be the discussant in today's conversation. Thank you very much, ambassadors. Thank you, Yihong. Thank you, Hamid, for participating today. Great to see you all online. Some of you may think that this is a strange moment to be talking about WTO decision-making, as the headlines are fully dominated by the US government's increase in tariffs back and forth, and by talk of reciprocity in the application of import duties, so forth and so on. But I guess we all would agree that this is precisely the moment to talk about decision-making, given the stress test that the WTO is currently undergoing. This is a moment, in my view, to reflect on the foundations of the multilateral trading system, principles as MFN, the security of concessions are all being tried in this stress test, and of course, decision-making. We also note that this is not a new discussion. There have been several proposals, some by countries whose ambassadors are represented here. And we also note that there was a retreat organized by the former General Council Chair and the DG last July on precisely this issue. I won't want to take much time, so let's dive into the issue. I'd like to invite the speakers and Hamid to make short initial presentations. We will then allow for comments, questions, and answers by the speakers and the discussant, followed by any comments and questions by anyone participating in the webinar. So with that, let me invite Ambassador Baptiste of Chad to be followed by Ambassador Bollinger. Monsieur l'Ambassadeur, over to you.
Thanks a lot. First of all, I want to apologize for my Franco-English, what I can say. Donc, I would like to thank, first of all, the organizers, the member of the Friend of Multilateralism Group, for organizing this important webinar and giving me the opportunity to share our views on decision-making at the WTO. All the issues we are discussing or negotiating at the WTO are highly relevant to sustainable livelihood, particularly for vulnerable people living in Africa. As you know, MC14 will take place in African soil. The people of Africa are already looking forward to seeing you in Yaoundé, to see you all in Yaoundé. We are working with our partners to ensure the success of this conference in terms of the decision to be taken at the ensuing result. Building on the meager result achieved at MC13 and the commitment shown by all members in Abu Dhabi, we are convinced that with real political will, we can conclude negotiation on the crucial issues for which it was not possible to reach decision in Abu Dhabi. I have been really, like representative of my country, I have been really very frustrated in MC13 because of one of two countries who blocked decision agreed by the majority. The WTO is a forum where members negotiate agreements and settle trade disputes. Part of the WTO usefulness lies in the way it takes decision by consensus. Also, in certain circumstances, as stipulated in Article 9 of the Marrakesh Agreement, a decision on an issue may be taken by vote, where each WTO member has one vote. The question we are currently asking ourselves is how, for example, we can build on the results of MC13 and find ways of moving forward on the issues on which it was not possible to reach a final result. We recognize that reforms are necessary, particularly regarding the mechanism for blocking decision, which is penalizing the progress of WTO negotiation and will have an impact if we take Africa in our population. The what we can say, a decision on an issue may be taken by vote, where each WTO member has one vote. The questions we are currently asking ourselves is how, for example, we can build on the results that we had already on MC13 and not go back if like everything has not been done, and find ways of moving forward on the issues on which it was not possible to reach a final result. We recognize that reforms are necessary, particularly regarding the mechanism for blocking decision, which is penalizing the progress of the negotiation. The impasse covers the appointment of new member for the appellate body must be surmounted. A fully operational dispute settlement body is the basis of a viable system that avoids permanent uncertainty for economic operators and businesses through the world. Decision must be taken. We must also ensure that protectionist measures do not harm our economies. We are concerned about the increasing adoption of unilateral trade measures that have an impact on our export. It's clear that the role of the WTO in the multilateral trading system needs to be resolved and reinvigorated if the WTO is to be dynamic and fully functional. How are we going to address power dynamics imbalances in approaches and the priority given to issues on the table, particularly those of particular interest to developing members? We need to ensure that existing decisions and mandates are implemented in a non-discriminatory manner, and that the objective for us is to safeguard the fundamental principles of the WTO as enshrined in the Marrakesh Agreement. We need a WTO that will enable us to modernize our economies, address historical imbalances, and achieve sustainable development goals. We must ensure that all future negotiations and agreements are concluded in a concerted manner, leading to a rebalancing of trade rules in order to create and preserve the political space needed to achieve our objectives. For us, the decision-making process has to lead and place our effort in a trajectory reconciling sustainable growth, strong job creation, stability, and trade predictability. We are aware of the difficult circumstances the world is currently facing, but you have no choice but to agree on the essentials if you are to ensure an inclusive and balanced decision-making process that allows constructive engagement on key priorities. We hope that our recommendation for better addressing capacity constraints set out in our proposal in WTO reform will serve as a guideline principle for meeting our needs and participating more fully in the WTO decision making. For the WTO to remain relevant in the 21st century, a key priority of current and future work should be to address the development aspiration of LDCs and developing countries. This includes poverty reduction, job creation, diversification in the production and supply of goods and services, and the harnessing of new technologies that will contribute to the growth of our economies and put us on the path to sustainable development. We reaffirm our desire to continue to engage actively and constructively in the negotiation and to find a way with consensual decision making. Thank you. I hope that you understood the 110 of the content of my intervention, but I can do it in French if you want. Okay, thanks a lot.
Much more than 10%, Ambassador. Thank you very much. That was very good.
Okay.
Thank you.
Okay.
Ambassador Bollinger, over to you, please.
Well, thank you and good afternoon to all participants. I would also like to thank you for choosing this very topical topic of decision making of the WTO for today's webinar, and also for inviting me to participate alongside with some colleagues. Let me also thank Lou for opening, and you, Victor, for the introductory remarks, and Hamid as the discussant who will come in at a later stage. The issue is indeed at the heart of WTO's ability to move forward, to make progress, and to prove the continued relevance of the organization. And let me at the outset make some introductory remarks about the uniqueness of WTO. WTO has an almost universal coverage, both in terms of participants and of percentage, as we know, of world trade. WTO is inclusive in terms of now. Could you hear me? I've seen that my I've been muted.
Inclusiveness.
Sorry. Okay. So, inclusive in terms of representation, the principle that all members, regardless of size or economic power, should have an equal say. Then the processes are open to all members, and there are certain inbuilt flexibilities foreseen for developing members and LDCs, and unique decision-making process with the practice. The practice, I emphasize that it's not a principle or a rule. It's a practice of consensus at its core that ensures a broad acceptance of any decision. The downside being, as we know, the increasing difficulty of the WTO to adapt the rulebook where necessary. We as members owe to our constituencies to reflect on what is working and what is not working and how it can be improved. How can we improve the decision making? I would like to mention 3 points. First, what can members do to better understand each other? Clearly substantiated positions and concerns could increase the mutual understanding. Positions that are based on facts and evidence will be more prone to create understanding for members' positions. We should also engage with members beyond the like-mindedness in informal dialogues in various configurations to improve the understanding of each and every one's position. We should strive to answer members' questions in good faith and in a timely manner. I can mention an example. We had, in the context of the IFD agreement, there has been this exchange with skeptical members on questions they put forward, and there are other examples. Second, improve or install the political role of ministerial conferences. Ministerial conferences are meant to formalize the adoption of WTO outcomes and that have been negotiated prior to these conferences. Ministerial conferences are not negotiating fora. Ministers should not be expected to negotiate technical texts. Only political decisions should be left to this level. In recent ministerial conferences, decisions were intensely negotiated during the conferences, which led to longer ministerial conferences and pose challenges in terms of inclusiveness and transparency. This does not serve the legitimacy of the WTO. And third, potential improvements of the work undertaken here in Geneva by ambassadors and by our colleagues, our staff. We should consider the TNC, the TNC body, the head of delegation or general council meetings at the senior official level to better prepare ministerial conferences by reviewing the status of negotiations and provide guidance and thus ease the conduct of ministerial conferences. We should consider inclusive transparency sessions for issues under negotiations to be decided upon during ministerial conferences in order to have everybody on board. In case of using small groups or green room formats, and not all the meetings that are in small formats are green rooms, and we need those formats, we should consider all members representing relevant views and members able to build bridges and facilitate consensus. We should avoid creating unnecessary bargaining chips. That's an important point right before ministerial conferences. Members should also refrain from overloading the ministerial conference's agenda at the last minute with issues unlikely to gather consensus. I know this is easier said than done. We know how in practice it works out, and at the end there will be some issues popping up. Now, more concretely on consensus. Switzerland is very attached to this practice, but over time, the way consensus has been used has led to the blockage of the organization. Now, what is the raison d'etre, the real meaning of the practice of consensus in the architecture of the WTO or formerly of the GATT and its governance? This can actually be seen in two ways. Firstly, as a tool to assert one's position against the rest of the membership, or as a protection versus power dynamics to protect members independently of their influence, their economic power, from being forced to give in where they have essential interests. No doubt, at least for me, the role of consensus is a second. It should act as a safety valve and not as a levy to leverage one's position. Over the last years, some outcomes have unfortunately not materialized within the WTO because of a restrictive use of the practice of consensus. For instance, when we talk about integration of plurilateral agreements into the WTO rules book. If this attitude is persisting, we see risks for the system as it might become irresponsive to evolutions of trade policy. That is why Switzerland has also co-sponsored with others a communication on responsible consensus in May 2024, which reaffirms the practice of decision-making by consensus, but calls on members to take into due consideration the systemic interests of the WTO while pursuing, of course, also national interests. Then also to adopt a win-win approach in negotiations by exercising flexibility and making compromises in order to reach agreement. And thirdly, to engage in negotiations based on facts and evidence. I think for the time being, I would leave it at that, and we certainly will come back to the discussion. I'm looking forward to listening to my colleagues and also to the discussion. Thank you.
Thank you very much, Ambassador Bollinger, including for reference to the proposal that Switzerland put forward together with other members. Next, we have Ambassador Pandyan of India. Ambassador, over to you if you can hear me, please.
Thank you, Mr. Prado and Mr. Lu. Good afternoon, friends. First, I would like to thank our Friends of Multilateralism Group for organizing this webinar and inviting me to speak on a topic that has attracted good discussions in recent years. Previous speakers, Ambassador Jean-Baptiste, Ambassador Erwin, brought an interesting perspectives to the discussions, including their papers put in the General Council for discussions, reflecting some kind of difficulties or uneasiness with the WTO decision-making process in terms of its efficiency and effectiveness in making progress, mostly with reference to rulemaking. It has been often argued that the WTO should be able to respond to current global challenges to multilateral trade, and decision-making process should support such effort. We all know that the WTO has been facing scrutiny over its decision-making processes, particularly its reliance on consensus amongst its 166 member states. In recent years, the new approaches to decision-making have been proposed to address the perceived inefficiencies, the stalled negotiations, and inequities. However, we should be mindful that the emerging proposals, such as the pitching for reforms to consensus rules, the increased use of plurilateral agreements, or for the alternative mechanisms deviating from the WTO's core principles, have the potential of perpetuating the divide further, thus causing much more damage than good. Let me dwell on this in some details and bring another perspective to the debate. It's very important to have a different perspectives in the topic. So the WTO is the cornerstone for global trade governance, tasked with facilitating trade negotiations, settling disputes, and establishing rules to ensure a predictable and fair trading system. The consensus-based decision-making framework as a fundamental rule is enunciated in the Marrakech Agreement. Whenever we talk of the decision-making process in the WTO, we must be fully appreciative of the power dynamics, power asymmetries that exist in the trading systems. And whether we like it or not, there are structural biases that are deep-rooted. Economic and political clouds have real and serious influence in the system. The agenda setting and negotiation may be dominated by those who have the capacities, expertise, and influence. Therefore, it is a necessity to have a system that, at least as a rule, uphold the sovereign equality and provide equal voice to every member, whether developed or developing, big or small. We cannot walk away from the foundational principles and lay down rules simply for the reason that negotiations on trade rules and decision-making have been complex and slow. This is natural, considering that the trade rules entail huge stakes for every member. Of course, not reaching a timely decision, even on the issues like TRIPS waiver on therapeutics and diagnostics, even in the situation of unprecedented grave humanitarian crisis, was really a cause of concern. And so also the commercial trade interest taking precedence over the food security or other humanitarian crises have been painful. Nevertheless, we are aware of these challenges and realities. Solution, whatever it is, lies in open, inclusive, fair, and transparent rule-based systems and deliberations. The so-called new approaches in the name of WTO reforms, in our view, bring in threat to equity and sovereignty, especially for the developing members. The proposals to dilute consensus would be favoring members who are higher in the pecking order of the power dynamics and have a greater resources and negotiating leverage. Historically, consensus has been a shield for weaker states, ensuring that they have a voice even if it slows the progress. Moving away from the existing rule and processes would only enable the dominant economies to impose rules that prioritize their interest, such as stringent intellectual property protections or market access demands at the expense of poor nations' developmental needs. This fear is compounded by the WTO's past, where the agreements like TRIPS were seen as have been forced onto developing countries during the Uruguay round. Transparency or lack thereof is also an issue. Approaches like informal small group, the green room processes have also received criticism on the account of non-transparency and lack of inclusive discussion. Take the case of plurilateral agreements. They clearly undermine the multilateral nature of the WTO. Plurilateral mechanisms where subset of members prefer to negotiate specific issues aim to bypass the gridlock of consensus by allowing like-minded countries to move forward without universal agreement. This approach seriously risks sidelining members, could challenge the position of comfort for certain members and amplify the influence of the powerful while eroding the WTO's commitment to inclusivity. I won't talk about the legality or the source of mandate on this issue, and rather I would not go deeper into it. However, any new decision-making approach that sidesteps consensus or impose stricter criteria for participation could deepen the already existing divide, alienating the key players and jeopardizing the cooperation. The stalled Doha development round exemplifies how that divergent interest can paralyze the progress. We should remain wary of any new approaches which could potentially fracture multilateralism, entrench inequities, reduce transparency, heighten the geopolitical tensions, and fall short of practical impact. While few see them as necessary to break what they think is an impasse, it is also to be kept in mind that prioritizing speed and flexibility over fairness and unity would not be in the overall interest of the organization. It is often argued that negotiating and deliberative functions in the WTO require serious reform. We are not sure what does it mean, as this could mean very different thing to different stakeholders, and every stakeholder could have his own perspective. Looking at the different perspectives of these stakeholders, some may be guided by the keenness to make new rules that could serve their own interest rather than the global common good for trade. Some may like reviewing the existing rules that have served well their purpose so far and now no more relevant for them. Some may want more space and opportunity to influence the discussions in the WTO, including in the WTO committees. Some may simply want to push their agenda through dedicated space, even if that means marginalization of the agenda sensitive to others or of the WTO existing bodies and framework. And for some, it may like to debate the issue just to remain relevant. On the other hand, there is a vast majority of the membership that may be critical of the system on account of lack of transparency, openness and fairness in the agenda setting, deliberation, negotiations, power-based dynamics trying to exert supremacy over the rule-based system, and factors such as the lack of capacity or expertise even in participating in the wide array of discussions across the committees and forums. Demand for flexibilities from them, while a few other could afford to remain inflexible, even on the critical issues like TRIPS waiver, technology transfer, food security, long pending mandated issues, and lacking interest on the existing issues on the table that are sensitive and relevant to the majority. For them, it is thus an issue of ever widening the trust deficit. Let us look at the different worlds that are exist on the table. The LDC members have been struggling for smooth transition. They just need a little bit of flexibilities, and if I may so say, a little bit of handholding for some more time. They find challenges in the existing rules in view of their severe capacity and resource constraint. We have found it difficult to deliver on that. Developing countries are in general grappling with the issues of policy space, need a bit of flexibilities as existing rules are constraining their industrial development. For instance, Africa is facing the issue of deindustrialization. Value addition is getting concentrated in few members, while most are serving in commodity and agricultural trade. Hunger, debt, growing inequality, digital divide, burdening of trade through unilateral measures are all stacking up against the developing countries. Sustainability discussions are getting skewed and bringing more burden on developing countries for no fault of theirs, while those responsible for the crisis have interest only in ensuring status quo for them. They have no willingness to take any responsibility and proportionate sharing of burden. The flexibilities that developing countries got at the end of the hard bargain, where they considered much more, are being rendered redundant. Similarly, all promises of financing, aid, support, assistance, preferential access to trade have turned hollow, with the commercial interest taking unprecedented priority. How could we imagine the countries that are facing challenges in existing transparency and compliance burden and seeking small support, be participating, deliberating, negotiating, and securing their interest in issues that are much more nuanced, complex, entail huge stakes for generations for their national sovereignty and security and for the survival of their people. It is not merely an issue of format or a structure that structure change in deliberative functions or negotiations. So at the end of the day, the issue is more deeply and widely rooted from the systemic point of view, in our opinion. Before I go to elaborate on what should be the right course in our view, I would like to mention that despite all challenges, WTO rules have served us well so far. And with the member-driven consensus-based approach, WTO have had good outcomes. We have seen new rules in the form of a TFA, Trade Facilitation Agreement, and Fish 1. There have been some outcomes in G90 proposals and LDC graduation issues, which may be suboptimal, but something positive. We have heard a decision on the export competition. Ministers have been able to agree on e-commerce moratorium for every 2 years extension. And we have a decision on ministers have been able to agree on several issues and given clear mandate, though pending in Geneva for progress in subsequent work. We have seen the creation of bodies like Working Group on Trade and Technology Transfer. Therefore, there is not much reason to be pessimistic about. This brings me to the final part of my intervention, which is, in our opinion, what we should be doing in WTO. What is needed is the transparency in the process. WTO decision-making has to be, in practice, open, transparent, fair, inclusive, consensus-based, and member-driven. This requires effective participation of all members, taking into account their capacity constraint and vulnerabilities. What is needed is addressing the issue of trust deficit. Developing countries, including LDCs, constitute 3/4 of the membership. Trust deficit has widened, as there has been little progress on past mandate in favor of these members. Long pending issues, including such as policy space, precise, effective, and operational SNDT, technology transfers, LDC graduations have not really moved despite developing countries making all efforts. There has not been progress. There has not been any progress on Doha development agenda. Concepts like single undertaking have often been used where they suit few countries. Then what needs? The WTO needs to remain focused on trade issues. While the basic trade issues and issues such as food security, trade, debt, and finance have remained under prolonged discussions with little or no outcomes, new discussions have been being pushed in WTO, and that too at times on issues that may not really belong to WTO. The next is the issue of JSI and fragmentation of the discussions. It's very important. Any discussion in the WTO is bound to be difficult and complex, as it entails serious implications for members. However, we need to endure this pain and take decisions and make rules which has ownership of entire membership. JSIs are causing fragmentations. Look at e-commerce. These issues are important for every member. It's important for all members. Under discussion for almost 27 years now. E-commerce moratorium has been under discussion, and the moratorium is being extended every 2 years at a time. Yet, certain members decided to frame rules through JSI mechanism, undermining the multilateral process without a mandate. And going forward, they also decided to leave behind certain members from their own group who did not agree to the so-called text, earlier stable text. So these are things happening, which is leading to the further fragmentation amongst the membership. What is needed? The strengthening of the WTO framework is the need of the hour. The mandated WTO bodies are the most appropriate place for deliberations, discussion, and negotiations. This institutional framework has to be preserved and strengthened. Marginalization of the WTO bodies like CTD, WGTTT, Working Group on Trade and Technology Transfer, Working Group on Trade, Debt, and Finance, and fragmentation of discussions outside the WTO bodies should be avoided. The role of Secretariat cannot be overemphasized in facilitating the discussions. And as repository of the institutional memory, the WTO Secretariat has to act neutral, guided by members, should not influence agenda setting or prioritization, and rather facilitate providing resources for evidence-based discussion, assisting members, particularly the members facing capacity constraints. Finally, let me conclude by saying that the stakeholders like FMG have important role to play in creating a right narrative in an impartial and fair manner, while trying to understand all perspectives. That way, this webinar is so useful. I'm grateful to all of you, and it's very helpful. I must thank all your efforts for organizing this webinar. Thank you very much. Thank you.
Thank you very much, Ambassador. That was very complete. Let me turn to Lee Yihong, my dear friend. Over to you, Yihong. Good to see you.
Good to see you, Victor, and thanks, Lou, and for having me in this very interesting and important topic discussion. And from the previous three ambassadors, we can see that when talking about decision-making in the WTO, people can see from very different perspectives. And for me today, I would just like to focus on the document China submitted and before the last July retreat on decision-making. And just a few words on the background of this document. After MC13, there have been many reflections on that meeting, and especially on the decision-making process. And among them, a couple of issues raised. One is about the efficiency and transparency and inclusiveness. And so from the retreat, we can see that there comes the common understanding on this. People recognize that small group discussions, including the green room discussions, will help to achieve the efficiency of this organization. But in the meantime, transparency and inclusiveness should also be ensured. And the other issue that really makes people very frustrated, and is that in the MC13, we have a couple of issues that's very relevant to today's development, and some of them are very relevant to the developing members, especially LDCs, feared to be harvested because a few members, even sometimes one or two members, block them. So that's the issue led to many discussions after the MC13. So China's document is mainly on how to better use consensus approach in this organization. This is also mentioned by the then GC chair, Norway ambassador, in his report on the last July retreat. I quote, "Consensus should not be used or misused as a tool for vetoing, but rather as a means to build consensus and foster genuine agreement." When WTO established, end of the quote, sorry. When WTO established, consensus approach was inherited. But if we look at the Marrakesh Agreement, consensus is not the only decision-making approach in the Marrakesh Agreement. So China's room document entitled Revisiting the Marrakesh Agreement to Improve WTO Decision-making, a Pareto Improvement Perspective, intends to reread the Marrakesh Agreement. We hope this revisiting could be helpful to understand the rationale of consensus approach and to see what we can do to make stuff done through this mechanism rather than to abuse it, which makes the WTO dysfunction. Our document recalls those articles in the Marrakesh Agreement on the decision-making, both include the consensus and those paragraphs on voting. So it shows that in the Marrakesh Agreement, one consensus cannot move out. There are other ways there for people to deliver. So one thing I would like to highlight here is that this document is not talking to adopt the voting approach or any implication to give a try. The intention of revisiting is to remind members that consensus is a means to serve the goal. The goal is to make this organization to function, to deliver, and to make progress. The goal is to preserve this organization as it brings benefits to all, especially small and weak ones. If consensus becomes a means to be used to block the WTO to deliver, then why we want to defend the means that not serve the purpose but even lead to the opposite. China, like many other members, wants to defend the consensus approach and to ensure consensus approach will serve the purpose as it is expected in the Marrakesh Agreement. If people look at the history, it is easy to find that consensus has never been a rigid practice or concept. It has provided flexibilities to address members' needs and concerns while ensuring that multilateral trading system can move forward. In our document, we identified 3 previous practices and situations that could help us to understand consensus better. The first one is differentiation. When talking about differentiation, it is not only about SNDT. Of course, that's very important. But in the meantime, if we look at history, developed members also got different treatment and exemptions. Also, members' commitment schedules, obviously, they are very different. Different timetables, different levels of commitments. And also ITA, Basic Telecommunication Agreement, and Financial Services Agreement are also good examples that members could do very differently with their own willing, with profits brought to all members. The second, implementation by less than full membership. Even consensus reached on the conclusion of negotiations, when it comes to the implementation, there has never been full membership implementation since the establishment of WTO, such as TRIPS Protocol and Trade Facilitation Agreement. Up to today, still there are some members have not finished their domestic procedures and have not submitted their acceptance to the WTO yet. The third one is agreements started by partial membership consists an integral part of multilateral rulemaking. The WTO remedy agreements and the SPS and TBT agreements, all involved from the codes in Tokyo round, launched and accepted by partial membership. And now we also have the GSI, and the India ambassador also mentioned about that. However, GSI never and does not conflict with the multilateral trading system. Actually, when GSI was first initiated some years ago, it is very clearly that people always do that to ensure that GSI is open, transparent, and inclusive. And some members, including China, we always call it pro-multilateralism. So that means with a large number of members here, and sometimes not everyone is ready to do something, and those issues are very important for WTO to start some negotiations or to start to look at. Those are ready could start first. For those who need more time, they can join the negotiations, and they can also raise questions and also join the agreement in a later stage. Actually, if we recall China's experience in the electronic commerce and GSI, at the very beginning, we actively participated in the discussions, but we were not part of that co-sponsors, not the participants. But gradually, as we have better preparations back home and we understood the situations better, the issues better, then we become part of that. So we see that is a very good practice for WTO with so many members with very different level of development. That's a good way to make WTO relevant and move forward, and also address the concerns and different development levels of members. So we never force anyone to do something that they are not ready yet, but we don't think if something will not harm those participants, it is also not so reasonable that those who want to move forward cannot move forward. So based on the above revisiting both on the Marrakesh Agreement and the history, possible ways in our document are identified and suggested, and in order to forge consensus and make this organization to deliver. The first suggestion: restrain from blocking consensus when there is Pareto improvement outcome in the rulemaking. When a rulemaking negotiation is taking place among a substantial subset, though less than full membership, if it achieves Pareto improvement, which means it makes at least part of the membership better off without making anyone worse off, does not harm the interests of non-participants and not reduce their benefits from the multilateral trading system, their members should exercise restraint from blocking the consensus, especially when it gets support of large majority of members and when many developing LDCs are expecting to benefit from such a negotiation outcome. And maybe here I would like to say that JSI on the investment facilitation for development is a good example of that situation. Second suggestion: there should be procedures to facilitate consensus when a decision with very broad support is blocked. So we do not force that member to join consensus, but if there is very broad support there, the one who wants to block it should give the very reasonable explanations on this. And so for that purpose, we suggest that a couple of things that maybe we can do. Number one, enhance transparency. Clear and convincing reasons should be provided when one member wants to block consensus. Number two, obligatory engagement. The blocking member should actively engage with others with a view to finding solutions to address its concerns. Number three, mediation. When there is an overwhelming majority in favor of a matter, a special consultative process should be set up to help bridge gaps and propose necessary solutions when bilateral conversations cannot address the issue. The third suggestion as a way out is that possible solutions to address the concerns of the dissenting members, taking into account the previous practices in the WTO and also referring to other negotiations outside WTO, footnotes, exemption, opt-out, and sunset clauses, among other ways, could help members to navigate when dialogues arise. So that's what our document is talking about. And before I conclude, I will touch a little on the JSI, because I see that JSI is now we have a couple of JSIs. That could be a way that to make WTO relevant and to have new rules adopted in this organization. So in here, I just say that for the JSI, we need build trust, especially with those non-participants. And in the meantime, it is also very important that everyone has the goodwill to have this organization function. So I will stop here. Thank you very much.
Thank you very much, Ms. Lee, Yihong, including for reminding us of the difference between the means and the goals. With that, let me ask our discussant, Hamid, to take the floor. Hamid, over to you, my friend.
Thank you, Victor, and good afternoon, everyone. It's great to see all good friends and colleagues. And I cannot agree more with the importance of the subject matter. I agree with a lot of what was said, and I thought I would say that this confirms a lot of my perceptions when I was following from outside what's happening in the WTO on this matter. And the first thing that comes clear to me is that we're talking about decision-making and the procedures for decision-making. That's a point that comes subsequent to a long process of negotiations and deliberations. So from a diagnostic perspective, it would be very, very important for us to see whether the problems actually we're facing are related to the procedural tool that we're using to finalize a process, or is it with the preceding stages of the process itself? Are we having the right kind of conversations? Are we having the right kind of negotiations? Are we engaging in the right way? And I think that's the stage where the substance of the matter is to be addressed. I recall from the old days of the Uruguay round, when the Marrakesh Agreement was negotiated, and it was decided by the contracting parties of the GATT at the time to carry over the process of decision-making by consensus. One of the points that were very powerful during that negotiation was that the consensus procedure itself is the best way to take decisions that ensure good preparation. If you have a consensus decision-making mechanism, that ensures that the preparation would have to be first class. It has to be as good as possible. Good meaning what? Meaning you have the right kind of conversations, evidence-based positions. You have a very clear laying out of the process itself. You actually have all the makings of a good negotiating process. So that raises the question in my mind, are we really, really having a problem with the consensus as a procedural tool, or are we having a problem with, as Cynthia said, the negotiating and the deliberative functions of the WTO? And there, I would completely subscribe to the view that we've been talking about WTO reform for years, but if you look at the negotiating function, for example, there are institutional challenges, apart from the list of negotiating subjects, the transactional negotiating files, be it agriculture or fish or this or that. There are institutional challenges that are hampering the negotiating function that require the right kind of conversations. For example, can we clarify the rules on plurilaterals? We need to clarify what the WTO rule book says. And we need to distinguish between plurilateral negotiations and plurilateral outcomes. And plurilateral negotiations, I would submit actually that plurilateral negotiations like the GSI, the only thing new about the GSIs is the name itself. But plurilateral negotiations have been the rule, have been the practice in the system for the past 75 years. Actually, the only truly multilateral round of negotiations we've had in the history of the system was the Uruguay round itself. And then even after the establishment of the WTO, we've had financial services, telecommunications, maritime, which hasn't finished. We've had ITA 1, ITA 2, We've launched the EGA, the environmental goods negotiations, and none of those actually required or needed a consensus decision to start with. Even the consensus decisions that were taken for financial services and telecommunications at the end of the other way around, they were not taken for the specific launch of the negotiations, but were taken for other legal reasons, which I can explain. This is not the time or place for it. So when we talk about plurilaterals, negotiations actually have been traditionally launched by a subset of the members. But when it comes to plurilateral outcomes, again, there are different types. There are types that create rights for non-participants, and we have seen that throughout the system. All the tariff rounds, and even after the establishment of the WTO, all the plurilaterals actually were applied on MFN basis through scheduling, right? So not all plurilateral negotiations produce plurilateral outcomes that don't create rights for non-participants. But back to our subject. Now, of course, Article 9 of the WTO agreement provides for procedural rules that says consensus is the rule, but when you don't have consensus, you can vote. And voting is part of the toolbox that we have. But of course, as was said by Lee Young and others, it has its limitations. You cannot conclude a substantive negotiation that would result in rights and obligations, in substantive rights and obligations by voting. You can't do that. And we have in public international law enough rules to explain this. The Vienna Convention on the Law of Treaties has specific legal rules and procedures for how sovereign states can accept treaty obligations, and you cannot create treaty obligations by procedural devices, be it voting or otherwise. Now, back to what we were saying, the question then is, how can we enhance the processes that precede the decision-making process, as opposed to trying to change the procedural rule itself? And when I look at the negotiating function, as I said, can we have the right kind of conversations to clarify the rules on plurilaterals, to clarify the application of special and differential treatment? Can we have a proper conversation about capacity building for developing countries and LDCs, as Senthil said? Capacity building focused on negotiating matters. All the capacity building programs of the WTO have been predominantly focusing on the implementation, but not on the negotiating process. And we have to keep in mind, when we look at how we can enhance all these preceding stages, of two important points here. The first is the increasing diversity of membership in terms of levels of development, but also weight in trade. And that requires a lot of information. And the second is the increasing the increasing complexity of trade policy issues. We just have to look at all the trade ants that we have. We have to look at digital trade to see the increasing complexity of trade policy issues that we're asking delegations to face. That requires matching capacity building efforts. And then let's have a good diagnostic view of the problem and see where the difficulties actually arise. And I don't believe that the difficulty is going to be with consensus. Actually, as I said in the beginning, and I repeat what was said during the Uruguay round, consensus as a decision-making tool is the only instrument that ensures good preparation. And good preparation requires the right kind of conversations, and right kind of conversations requires the right kind of thought leadership. And with that, let me end here, but I would be more than happy to unpack some of those issues as we go forward. So back to you, Victor.
Excellent. Thank you very much, Hamid. That was really thought-provoking. I was going to suggest that we ask the panelists whether they have any questions or any follow-up amongst themselves before we turn to the rest of the participants. But I see that Ambassador Baptiste has sent a comment here and a question, which are very interesting. He says, I've seen during MC13, I spoke to many delegations about cotton. The African region had a consensus amongst themselves around the document, but it was blocked by 1 or 2 countries without any reason. They said that there was no agreement on agricultural, so they blocked the cotton document. In this case, what can we do? And this is a very relevant question, and I think we, should give it some thought. But before going into it and asking whether others want to comment on Ambassador Baptiste's question, let me turn to Ambassador Bollinger.
Well, thank you very much, Victor, for giving me the floor. I would like to come back to some of the statements made by colleagues just a couple of minutes ago during their introductory comments they made. Maybe just starting with my colleague, dear friend Senthil, when he mentioned that we shouldn't dilute consensus. Actually, the proposal made by some members, including Switzerland, was not at all to dilute consensus, but to get back to a consensus that is really also in the interest of the membership, of the whole membership, and only use it when national interests are at stake, not just using it to build up bargaining chips. It's also a question of good faith. Then another point I would like to raise is the Ambassador Pandian also mentioned examples of where we didn't move forward like some of the old mandates, and then you also mentioned the TRIPS waiver, and I would like to mention here that there were also documents and studies that were brought forward to the membership that showed that the TRIPS waiver didn't function the way it was actually perceived, because there was no request for such a a license that was then used, and I don't think that would have been something that would have helped in the context of the pandemic and would have saved lives if we had gone further, because we had this waiver for vaccines. And maybe just another point I would like to mention is I think it's important that we take responsibilities, all of us, and not just defend our own positions and interests. An example I can show you is it's not only valid for Switzerland. Let's say that the fisheries subsidies agreement, Switzerland was the first one to ratify, although we don't have any, we have not really participated in negotiations because we have no real stakes in that. But we believed, and we still believe, this is an important agreement, because it has also this, it's on the nexus of trade, but also on sustainability issues. So, and it's something that is important for many members, certainly also those with artisanal fishing. Then maybe just to thank the colleague, my colleague from China, Li Hong, for her presentation, and I also believe that consensus is not a mean to by itself. It has to serve a goal, and that's important. And maybe one point I really found interesting that Hamid was mentioning, namely that we have to ask ourselves if the problem lies with the procedures or with the substance. I mean, is it that we do not engage in the way we should with others, and then we get to something, a result, and then it won't matter if it's by vote or by consensus, we won't find a solution, because maybe the substance is not something that the big membership or the pro membership can live with, because we didn't listen to each other, we didn't take into account some of the aspects others or that are important to others. That would be some of my remarks. Thank you.
Thank you, Ambassador Bollinger. Let me turn to Ambassador Pandian, who has raised his hand. Ambassador, over to you.
Thank you, Mr. Victor. Thank you, Mr. Hamid, for your discussion remarks. Yeah, rightly you said that the decision-making process is not a consensus process, is not a problem, but you may be raising some of the issues during the negotiation. That's what we have been seeing, that the diagnosis of the problem is very important, because misdiagnosis will lead to different results, which will be much more harmful to the systems. So that's why it's very important to diagnose the problem. We already said that in my opening remarks, that the issue is not the negotiating phase or the consensus-based process, which is the issue is much more deep-rooted, mainly because, see, there is a stalemate in many of the issues where the ministers have given a clear mandate. I think the Ambassador Chad has given a thought on the post-pending mandates. See, the post-pending mandates have the highest legal standing. No one can question, and we all agree to the mandates, and the sufficient trade-off have been achieved. This was a give and take in good faith negotiations, but not following the mandate and trying to create another mandate, or trying to interpret in a different way, that leads to a trust deficit. So that's an important issue that has to be addressed to bridge the trust deficit amongst the members. Number one. Number two, if the members are not coming together for a consensus-based decision, it means there are 2-3 scenarios. One, maybe the issue would not have come for the maturity for a particular decision. Maybe members are trying to achieve a early harvest, and some more negotiations are required, or some more compromises are required, so that to have a balanced national interest. And so here there is a substantive angle is involved. It's very important. We should not forget it. Substantive angle is involved. It's not only the the decision-making process or the process of the negotiations. So it's for example, another issue I wanted to give, the SNDT. But even the many members have been talking about the precise, clear, and effective and operational SNDT, but that's not being cleared. And the way of interpreting the rule after having negotiated so much and come to a conclusion, and still people try to interpret in a different way. Even I can quote 2 or 3 examples from my own experience after observing here, though my tenure is not very, in the sense long in WTO, but still I could sense that the people even are not willing to accept the CTD as a focal point for development. And it's because of the language. CTD is a focal point, or CTD is the focal point. Even that is not, being properly interpreted in good faith. And people have a difference of opinion. If such is the case, the people who are raising the issue should give us also that. Then what else the other committees which could be the focal point for development agenda? There is no answer for it. So I think these are the small issues, interpretational issues. The language precedes over the good faith negotiated outcome. So it's very important. I wanted to make it a point. And apart from that, the one more thing I wanted to say, that as Mr. Hamid said, we all know that the plurilaterals are the integrated part of the WTO's architecture, no doubt about it. And even the founding members clearly saw there may be a plurilaterals in future. That's why they made rules under Article 3.2 and 10.9 and everything. But it's exceptions. It's not a rule. Number one. Number two, there is a process of negotiate. There is a process for initiation of plurilaterals. There is a process of addition of the plurilaterals into the Annex 4. They're all the process which has been given. That's why India put up a paper on how the members are trying to circumvent just simply putting a plurilateral way of mechanism as a basis for decision making. That's going to be a problem. I can quote I can have just 2 quotes. Somebody said, the WTO's future hangs on bridging the divides. Push plurilaterals too hard and you will fracture it beyond repair. That's the one quote I wanted to make. The second quote I wanted to make is, we can't just have a few countries moving ahead with the plurilaterals while others are left behind. It is not sustainable. The WTO must deliver for all, or it risks becoming a club for the powerful. So these 2 quotes, I just leave it to the members to observe. And the other thing I wanted to mention is basically, the consensus building is an important, because it takes time. I remember, I know that it takes time, because the international policy coherence will take time. The rule for international cooperation will take time. But however, we have to work on how the trust can be built amongst the memberships. So what are we doing exactly? So I will just say from my own experience. My views are personal. My own experience, what I'm seeing here, it's like we have a green room negotiations. Most of the members are not participants of the green room negotiations. Then we divide amongst the membership. We divide amongst even the developing countries. We give some waivers for some group. Then some of the groups members go away from the negotiation. Then some of them we give a de minimis. Then other members, some group goes away. Then we come for the differential SNDT. Then the people go away. Then finally what will happen? They're left with only 2-3 members who are having a real substantial issues. And this is not a way, the good faith negotiation will happen. The good faith negotiation will happen by inclusion, not by exclusion. It's very important to have a negotiation by inclusion. And it's important to have a negotiation by accommodation, not by excluding the members from the negotiating scene. So this is my medical. I thought that I'll come back and share from my experiences with the limited tenure I had in WTO. That's only 10 months. Okay, then I thought I will just explain what is happening here exactly. Thank you.
Thank you very much, Ambassador. That was very clear. I see the Ambassador of Chad, Ambassador Baptiste. You have the floor.
Thank you, Chair. Thank you very much. Now, I agree with Mr. Hamid about the consensus. It's the best way. I agree totally with that. But we need to find a solution. I told you during the MC13, I think that there is no delegation with whom I discuss about the document on cotton proposed by the African region. We made a lot of consensus. I remember that Ambassador of New Zealand told me that this document, why you are doing that? Because with the content of your document, it doesn't matter nothing. But I told him, cotton for Chad, for other African countries is an important issue. It is issue of development. It is issue of employment. It is issue how we can transform our cotton in my country and things like that. And we can use the opportunity of this meeting and the country who has done better than us, how to replicate or to receive help from them in order. It's an issue of development, But some country doesn't mind because cotton doesn't mean anything for them. But yeah, at the end, when I am telling you I have done all the delegation, I told you I have done all they agree on the content when we have made consensus. But at the end, one or two countries, they say, we don't have an agreement on agriculture, you will not have an agreement on cotton. They block the document, 2 countries. In this case, I think that consensus is good, but we need to say the interests of our countries sometimes. We are here in Geneva for that. It's the issue of development, it's issue of, economy, it's issue of employment, it's a lot of issues for Chad, agriculture or cotton. It's the base of our economy, and it has been blocked. In this case, I think that despite the fact that the consensus is the normal way to adopt a document or to go ahead, sometimes we need to have a vote, because the majority, when I am telling you the majority, European Union, US, all the country, I am telling you all the country, we need to have a way to have a solution. In this case, I think that the vote will be the better way for us, because it's issue of development of our countries in our African region. If we don't, we don't succeed to have little things like cotton. How we can have an agreement on agriculture? Our interest, I know that we don't have the same interest sometimes. I know that our problem is not the problem of other countries, but we need to have solution. We will have the meeting who will come in Cameroon. We need to have, if we don't have an agreement, we need to have something in order to improve the situation of our population. I don't know if you understand, but I was very frustrated in MC13, and I hope that MC14 will be better. Thanks a lot. Sorry for my English again.
No, thank you. That's very clear, Ambassador. Thank you very much. And I think many people share your frustration. Ihong, over to you.
Yeah, so thank you. I asked for the floor again. It's just what Chad Ambassador mentioned. It's just the thing that's very relevant to our Zoom document. Actually, cotton is not the one issue that because of one or two members block that fail to fly. And also there are some other issues in Abu Dhabi had the same situation. Also recording, some people said that there are many issues. People have very different views there. So when we're talking about the situation Chad Ambassador mentioned, I see that it's more urgent for us to address, because if issues that there is no convergence, that means we need more work to seek more support. But what Chad Ambassador mentioned, and what also the IFD matched and suffered in the MC13 is that very, very broad support, just one or two members cannot join the consensus. So that is really, I guess that is really a problem that actually that means that is mature. That issue is very mature, but because one or two members cannot support, then we cannot have it. So that's really, I just echo what Ambassador of Chad said. We need to find a way to address such kind of situation. Thank you.
Thank you very much. Hamid.
Yes, thank you. Just quick 3 points on some of the comments made. Now, what I said about consensus actually is that it cannot be a way to conclude a negotiation on substantive rights and obligations. What I should have added also is that voting can be used. It is in a practical way, but not on matters that affect the substantive rights and obligations. You can always use voting on institutional and procedural matters. Now, there is perhaps a dividing line, a very, very fine dividing line that needs to be drawn carefully between these two types of issues, because and I don't want to be too much of a legalist about it, but it is not possible to create a new substantive obligation or affect a treaty obligation that belongs to a member without the proper legal procedures provided for and the customary rules of public international law as codified in the Vienna Convention. But you can vote on matters that don't affect substantive rights and obligations. And I think if we get stuck, because I completely see the point and the concern, and I appreciate what was just said about issues with broad support. And this is also the case for investment facilitation now, as was the case for cotton. If there are issues with broad support, then it becomes really, really challenging. How could these matters be resolved? If you resolve them by voting, and that's a choice members have to resolve such matters by voting, but then there has to be, perhaps legally speaking, an accompanying device that prevent any kind of implications for members that do not accept. It depends on the matter at hand. Of course, there is no, we can have rules, but of course, every situation has its own challenges. And one last comment I want to make about trust, because there has been, over the past few years, repeated comments about the trust deficit. And indeed, there is trust deficit. But let's look at the history. And I never look at history for reasons of nostalgia at all. I look at history because it teaches us a lot about what works and what doesn't work. And we shouldn't repeat old mistakes, and we should not waste our time reinventing the wheel. But what generated trust on previous occasions was actually two important things. First, the clarity and information, sufficient information and knowledge about the matter at hand, because if some members don't know, are not aware of the issues and its implications, the safest thing is to say no, is to block. That's a natural result of the information deficit. So information deficit results in trust deficit. And the second thing is transparency and inclusiveness. And I agree very much with what was said about a good process should be inclusive, not exclusive, definitely. Now, with these two critical factors, I think we can create trust. But I'm not saying it's easy. It requires a lot of work, and it requires a lot of information and substantive discussions. Back to the first point I made in the beginning, which is we need to have the right kind of conversations. So back to you, Victor. Thank you.
Thank you, Hamid. I'm just going to check whether any of the speakers want to come back. Otherwise, I'm going to open the floor for questions from other participants. And I see that there's one question from the audience that in the chat. I'm actually going to read it because I think it's important. It has to do with a lot that has been said. It's about the JSIs. It says, we're grappling with two fundamental questions regarding the JSIs. First, should a JSI that evolves into a plurilateral require consensus before its launch? And second, can a plurilateral agreement be added to Annex 4 without consensus? Are we governed by multiple rules in this regard, or is there a single overarching rule? Hamid, you have thought a lot about this and even written about this. I wonder whether you care to give a reply, but I see Lou has also requested for the floor. Do you want to take this question, or do you want to say something else, Lou?
Let me help take off a little bit burden from Hamid. So I'll make a quick comment. Great. And I'll come to this, in between I will come to this question, very good one. For me, I enjoyed very much listening to all the interventions by ambassadors. I in particular agree very much to Chad ambassador saying that we need to avoid further frustration and find a solution to move us ahead. I think that's the key. From all the interventions, I don't see any intention to go around the consensus or to abolish it or one way or the other. What I see is more how to best use this consensus as a tool and to move us ahead instead of a kind of abuse of the consensus by blocking by a few vis-a-vis a great many. You heard from Chad ambassador saying on quota you have like 164.5 vis-a-vis 1 or 2. And on IFD, you see that is 128 vis-a-vis 3. On dispute settlement is almost 165 vis-a-vis 1. So I think that's the thing. So coming back to the question is that I don't think that you need a consensus to launch or to start discussion or to do anything. because members, as we used to be, we will just find a room, get a group of members interested, and sit down and discuss. If we find it is worth trying with a broad group, we'll bring it to the preliminary session and seek further kind of interest from broad members for further discussion, and then potentially becomes agreement. Of course, consensus here is needed for decision making once we want to bring it to the WTO. But my sense here is that members won't wait for you to say yes before they can do anything. You see, on dispute settlement, MPI is there. And you see that on e-commerce, if nothing happens here, we already have the DEPA outside. Members already have a structure and quite some applying to join that. And we see a lot of regionals touching upon a lot of things which couldn't be dealt with in the WTO. So I think that kind of thing probably is even a bigger and probably more worrisome fragmentation than the kind of probably small group and then kind of things we try to do here. So with that, I just conclude. I think here the proposal is to have a process, have a procedure where you need to explain, you need more transparency, and then you need more dialogue to build, to help build more trust among members. I think that's probably for me is a key step forward, and then I think we should find a way to put that into place in the WTO for further discussion, so we could have a kind of WTO which is function and which can deliver and avoid frustration. Thank you very much. I stop here.
Thanks, Lou. We have Alejandro and Ambassador Pandian. And let me just say, we just saw there's a question from Peter van den Bosch in the chat asking whether any panelists have insights into the position of the Trump II administration on WTO decision-making. Thanks for bringing us back to a bit of reality here, Peter. But Alejandro, have you... you no longer have your hand raised?
Yeah, I'd like to say something quickly.
Okay. Lou, can we extend a little bit the time of the discussion?
Sure, and this is a really dynamic discussion, so as long as you want, or as the panel please send. Yeah.
Okay, thanks a lot. Alex.
Very briefly, I'd like to pick up some points that have been said. I fully agree with Hamid about you cannot create treaty obligations or added diminished rights through voting. There has to be consensus. But by the same token, there are other things, like he said, which can be voted upon. For example, admission of observers, or setting the dates to begin the process of selection of appellate body members. Those are procedural issues. Now, let me combine that with the idea of abusing. If there's enough political pressure in the system, it becomes very difficult to oppose a consensus. Take, for example, 2001, the United States was under severe pressure to agree with the TRIPS amendment, etc. And finally, after 12 months, they yielded after some cosmetic changes to the language, because the rest of the members exercise enough political pressure. My final point, if you abuse the system, if you abuse the consensus, what you get is, if you abuse for example, paralyzing the selection of appellate body members, you get MPIA. If you abuse members from going forward on particular issues they want to have better international cooperation, you get JSIs. So this is a consequence of abusing the system, of opposing consensus for no objective reason. And therefore you get the membership that they will bypass somehow and find a way to move forward. Thank you.
Thank you, Alejandro. Ambassador Pandian.
Thank you. Just I heard what Mr. Lu said in his reply for the question whether the initiation of process of the JSI requires mandate or not. Yeah, we have a different view. That's why India has put up a paper in the GC regarding the legality issues. Whether the mandate is there to initiate negotiation under the unilateral or not. And the article, in our opinion, the Article 3.2 is very clear. It says in 2 sentences. The first sentence talks about the existing multilateral relations. The second sentence talks about the ministerial mandate. So I think so we have different views, and we have been discussing these issues with the proponents for quite some time. And we have been not only discussing this legal issues, even we are discussing about the other issues as well. And some of the members also raised the questions in the General Council regarding this. I think it has to be taken in totality, and I think the members should discuss well with each other, and the proponents are engaging with us. And other members as well who are having the same views. And it's very important to have even we are the ones rather found a solution in WPDR, in what do you call this JSA on services domestic regulations, SDR. We only suggested how the way out can be proposed for getting into a multilateral work under the WPDR route, and initially it was suggested like innovation. The what do you call the JSA is looked upon as innovation, on the as like a Trojan horse, we can say, and we were the one jumped into and suggested the ways to make people, to accommodate people and find a ways and all. So the legality issues is always is a debatable, as we have a different views here. That's why India placed a paper in the General Council. Thank you.
Thank you, Ambassador. Hamid.
Hamid, you're muted.
Sorry, yeah, I hadn't realized. I think Senthil raised a very important issue here, which is illustrated in the example of domestic regulation. You see, with increasing diversity of membership and increasing complexity of trade issues and all that, we need to think how to best use the elements of variable geometry in the treaty architecture of the WTO, so that we can have as much as possible customized outcomes that cater for all members, regardless of their different situations, accommodate different situations. And that brings to my mind the concept, which domestic regulation is a good example of, the concept of having a negotiated outcome binding on a group of members, but create rights for all members. This is a concept that existed throughout the life of the multilateral trading system, even since the very first rounds of tariff negotiations under the GATT. A subset of members would get together and they would undertake certain commitments that they have negotiated, and they would be scheduled and subject to the MFN provision, whether it's the GATT or the GATS now under the WTO. Now, that concept has always been there and has always been applied. Negotiating outcomes by some, but creating rights for all. Now, if that is an acceptable principle and practice, it was only done through the technique of scheduling. But can we do this through a new standalone agreement, which would be binding on some, but create rights for all members. Maybe that's a situation we need to think about regarding investment facilitation. Because in any outcome in which there is no free rider risk, or in outcomes where the nature of the obligations have to be applied on a non-discriminatory way anyway, because they're regulatory matters such as investment facilitation, it comes to mind as very similar to the new outcome on domestic regulation. But again, we need to have the right kind of conversation so we can navigate our way through the right kind of solutions. Now, two questions that were raised, Victor, and you threw at me earlier very quickly. The answer to the first, which is no consensus really is needed to launch a plurilateral negotiation. There's nothing in the rule book that says that a consensus decision is needed. And this has been the practice over the past 75 years. The second question, do you need consensus to add an agreement to Annex 4? Of course. This is actually in the black letter of Article 10, paragraph 9 of the WTO agreement. But again, consensus is just the procedure, it's the form. But what precedes it, I think, is what we're struggling with here. So back to you, Victor. Thank you.
Thanks, Hamid. Again, I'd like to come back to the question posed by Peter van den Bosch and ask whether any participant in the webinar, not only the speakers, and I'm not looking at any of the friends based in the US, whether there are any insights into Trump 2's position on this decision-making in the WTO. Alan, please. I was not looking at you, but go ahead, Alan, please. Need to unmute.
I preface my remarks by saying I don't know the answer because no one knows the mind of the president. However, what is clear is that he has not called for withdrawal from the WTO, step one, by the United States. Of course, there's a debate of onlookers as to whether it's better for the United States to be outside or inside, depending on its conduct. But given the fact that the United States has indicated nothing about withdrawal, has gotten the Senate to have a view of a nomination of a deputy USTR who would be ambassador of the United States to the WTO. It would appear that the United States is in. Do I feel that there is any indication whatsoever of movement on the dispute settlement issue? No. That the United States is quite comfortable appealing into the void, letting others be bound if they care to be bound by an MPIA, an alternative. But I cannot picture, sitting in this vantage point, any indication whatsoever that the United States is ready to negotiate a change in position with respect to dispute settlement. Namely, it will not engage. That's my view.
Victor, you're muted.
Sorry. Hamid, thank you, Alan. That's very, very clear. Hamid, did I see your hand going up?
Yes, but when I saw that Alan was coming in, I thought we would hear from the authority first. But my view, watching from afar, is that the U.S. is not paying that much attention really to the WTO at the moment. We have seen the report that came out of USTR with a list of concerns about the WTO. when it's at the tail end saying we're ready to engage. But I don't see from the approach of the White House to trade policy that there will be any kind of appetite to be bound by any rules or procedures, let alone invest time, effort, and political capital in reforming the WTO. So I don't have a lot of expectation on that front, which actually raises another question that was my pretext for taking the floor now, which is it's about time, I think, for those who care about the system and care about preserving the multilateral rules-based system as opposed to a power-based system, to get together and provide the kind of coalition-based leadership that is needed to provide the thought leadership for reforming the organization. Because I think the kind of international environment we're living in now and the geopolitical situation would indicate to me, at least, and I don't want to be too pessimistic, that the window of opportunity for reforming the WTO and preserving a rules-based system might be closing faster than we think. So back to you, Victor. Thank you.
Thank you, Hamid. I mean, I guess with that, we could call this webinar to a close. Fully agree with you. I just want to point out something that Lee Yihong sent us in the chat, saying that at this point, she's referring to Peter van den Bosch's question, deliverables are more important and needed than ever. So efficient decision-making is more urgent. And just want to echo your call for leadership in a coalition-based manner, Hamid. With that, let me turn back to Lou. Over to you, Lou. Thank you.
Thank you very much, Victor, and also to Hamid, and also all the ambassadors for really a great discussion. I think that this gives us a lot of fruits for thoughts for the weeks to come, especially as Hamid said in his conclusion remark, is that we are really in a situation where we need to see those who are still kind of concerned about the importance of the system and to get together and see how we can move ahead. So I think that's a very good sentence to conclude this session. I have nothing else to say, but just to let the audience know that given the situations, we are probably doing a little bit more than we normally do, a kind of 2 sessions a month. So I think you have received an invitation for high level dialogue with team growth to be moderated by John Weeks. I think it's going to be next week. And the week after, we're going to have a session on the EU trade policy under the new commission, which will also be very important when the leadership from the EU and the middle grounders is needed. After that, we'll continue to send you invitations for other sessions to come. The final point is that I take this opportunity to welcome the 4 new members to our group. I will just try to pronounce their name with my Chinglish here. So there is Hossein Planck, who is here with us. So welcome, Hossein. And also Trudy Hasenberg from South Africa, Ahmed Ihab Kamaladin from Egypt, and Sumantha Chaudhuri. Sorry, I forgot where he's from. But anyway, this will further
Samantha's from
add
India.
to India. Sorry for that. Yeah. And yeah, he actually was a delegate with us in Geneva. So I think they will further add to the richness of our group and diversity. And I look forward to working with all of them in the future. So with that, thanks to you all, and see you next time. Bye-bye.